opposition to the continuation of a non-conforming use. You know, Schaefer, the city of Los Angeles, is a famous case. It says there's a strong public policy in favor of limiting non-conforming uses and against expansion of such uses. And that's site 237 Cal Ave 4th, 1250, and specifically page 1263 from 2015. So this, I think, would be properly considered to be a illegal non-conforming use, meaning that the city is not did not step in and require additional trees to be installed. And I guess what I should have added up here is a copy of existing site. You can look at the notice of decision, which shows that these trees are not there. But first off, more recently they burned down, but before that they were removed in some other fashion. And because of the Woolsey fire, there are no trees around it. But these trees, I think, were removed somewhat before that point. So it is entirely, basically, nearly a bare pole from the standpoint of these installations. And what that means is that once it's not shrouded by these and camouflaged by these trees, on top of that situation, there also is a much fatter, which we mentioned above in the prior slide, radio shroud. So there's additional elements that make this more conspicuous than was the intended design and was the basis for selecting this site and approving it as consistent with the required findings. I think those two combined elements mean that there is an aspect of the modification that is making it worse than would otherwise be in the surrounding conditions. And I think that is an example of defeating concealment in the context of a site that was approved well before the standards that we have today were on the radar of a city. See, so that was 13 minutes. I hope I'll have a few minutes for rebuttal. Mr. McCullough, would you like to add something at this point?
I can talk about the Bushes on Busch a little bit more. I suspect there's going to be some rebuttal on that. So you can close on your points and give it back to the hearing officer.
Thank you. That's what I'll do.
Okay, great. Applicant, you want to make a presentation?
Yes, I do, Mr. Burns. So I want to address the concealment elements here, and I want to address the SCE piece as well. So let me start with concealment, because we just saw that presentation, and in fact, it's still on the screen. The 2014 order implementing Section 6409 allows minor changes to the size of the equipment. I mean, that's clearly, like, the whole idea that not every change is a substantial change is fundamental to Section 6409, and it's fundamental to 1.6100, the FCC rules implementing that. And under appellant's view, and as I understand it, no change in size, no increase in size would ever be allowed, because even though the first four points defining what a substantial change is allow for flexibility, allow for some increases in height, allow for increases in protrusion up to certain limits, appellants would argue that all of those would, in every case, make the site more visible, make the facility more noticeable, and then therefore, on their view of a concealment element, that would defeat concealment. But that can't be the case, right? We know that this statute was expressly with the goal of facilitating deployment, allowing physical changes, and it was saying some physical changes are substantial, some are not. And the idea that defeating a concealment element is a separate prong was a recognition that there are some things where the condition of approval was a specific concealment element, such as the brown paint or facing on the street side, that were actually noted in the original permit as conditions of approval. And if you defeat those, you know, that's a substantial change. But just making something bigger, just having it be visible is not. And I think that's actually really proven by two things. One, if we look back at the League of California Cities case, again, the tree line, right? One is the difference between a change in the height. That change in height might be allowed, but if it puts it above the tree line, and specifically the condition was, you know, that tree line's there, stay behind it. We know that, you know, that in the court's view could be defeating a concealment element. But we've also talked about that the modification has to be what defeats the concealment element. And Mr. Strauss expressed some, I think, skepticism that that's the law, but it's right there in the rule, actually. So the portion of 1.6100, section B7, that defines what a substantial change is, you just have to read the sentence. Substantial change. A modification substantially changes the physical dimensions of an eligible support structure if it meets any of the following criteria. And then criteria 5 is referring back to the modification, if the modification would defeat the concealment elements of the eligible support structure. So again, in the situation where there's specific concealment elements, and those we know from the permit, we're limited to painting it brown and doing the street side location. Those are the only ones that they've identified for any of these applications. That might be defeating a concealment element, but simply the fact that the trees aren't there anymore is not, and neither is the fact that the shroud is a little bit more visible, or that the shroud plus the trees makes the thing more visible. And again, that's just inherent in the statute. Some things can get bigger. That was the idea. Congress passed Spectrum Act as policy. The FCC implemented it as a policy choice. And they were balancing the need for deployment and advanced technologies against other things, including state and local flexibility and regulatory authority. So I think with that, I'll just point out that the Douglas County case, which came up again, it's the second case that's relevant, and there the trick is, yes, something got bigger and it was found to be defeating a concealment element, but the reason was that pole was supposed to look like an ordinary utility pole, and it's clear in the case that there was agreement that this was supposed to look as close as possible to an ordinary utility pole. And I want to read a passage from that case. This is from the one with the site that we've been talking about. The case was actually amended and restated, but this paragraph didn't change. So I'm just going to read this just a second. So the court first notes that the county had described the proposed alterations. Remember, it used to be, looking like a regular pole, just, like a pole. It said the alterations would make the tower look like a marshmallow on a stick. And then the court explains that a generalized desire that the pole look like a utility pole or blend in with its surroundings is not in itself a concealment element, but by the same token, the undisputed facts in this case make it clear that the limitations on height and width in the original pole imposed as part of the original approval process are concealment elements. From the start of the process to the end, the county insisted that the pole be made to look as much like existing utility poles in the area as possible. Means of doing so, which is to say the concealment elements, including the shrouding of the antenna, the paint color, the height and width of the pole. There's no explanation for why the 35-foot height and 18-inch width limits were included other than that. And in this case, they were changing the 18-inch width.
Can you make sure you have time to just address the argument about the SCE manual?
Yes, I will. And so, sure, I can do that. Just noting that there's no evidence of abandonment here. And then just regarding the SCE, I think, our response, and I'll let Mark Myers weigh in here, was just that the site went through the JPC process. As part of that, the SCE authorization is noted in the record. SCE delivered power to the site. There is no evidence that there was ever an issue with the design, or the SCE ever raised an issue with the design. If they didn't approve the design, they had all kinds of opportunities to issue a notice to Crown Castle and have it corrected. And frankly, if there still is an issue with the design, there's still the possibility of that being noticed and corrected. But that doesn't make it a basis to deny the request, because it doesn't change the fact that this is an eligible facilities request as defined by the statute and the FCC's implementing rules. So not every, sorry, go ahead.
Does the record support, does the record support that this has been installed and SCE has delivered power to the site?
I believe it does.
Yeah, it was originally installed in 2013.
Okay.
In 2000, sorry, sir, if I could
Hold the time, please. Thanks.
I don't believe there's anything in the record that indicates it's been built or that it has power. There is a there is a letter threatening to build it. But and perhaps Mr. Galloway can point to something that's not part of the record, and certainly wasn't the case when it was approved by the director. Okay.
Okay, Mr. Galloway, go ahead. If you could restart Mr. Galloway's time. Thank you.
Yeah, so I mean, there was a deemed approved letter that was sent by Mr. Myers on April 13th, 2026. There, the notice of decision, I believe, also reflects that the SCE authorization was there. I'm not seeing anything in the record immediately saying that the latest modification has been built. It is my understanding that it has, but I'm not testifying to that. I have no firsthand knowledge of that.
Okay.
Mark, I don't know if Scott or Mark, if there's something in the record that you see here that indicates that that has been constructed. I simply don't see that in the record.
I'd have to look back through for something specifically at the time when it was originally installed to see if there was something that was provided in that. But because the site's been in existence for this time and on air, providing traffic for X number of years, that's more or less the sort of the evidence, the permit we had to bring it up on air in the beginning. Any alterations were submitted to them to follow their process and procedures as set forth in that manual. And we've received their subsequent approvals, but that has more to do with the change in attachments.
Six minutes and 27 seconds.
Okay. Mr. Gallo, does that conclude your presentation?
I think it does. I was just looking to see if the SCM report that actually appellants included in reference to site visit. And I would just have to look through that to see if there's a reference to a more recent visit showing that it was operating. But I can't scan through it fast enough to probably answer it in 20 seconds. So.
Any rebuttal from the city?
Yes, just pointing out that the plans as shown are compliant with the eligible facilities request thresholds under FCC, showing no more than a 6-foot projection measured from the face of the pole. As far as any SCE regulations that could conflict with that, that's what the final authorization and other attachment authorizations prior to permit issuance are for. So if there is a noted discrepancy, then that would be corrected at that time. But at this point, it wouldn't be a basis to deny the eligible facilities request, again, because it is demonstrating that it's compliant. I'd also like to point out that since the original approval of the minor conditional use permit 215, there was wireless telecommunications facilities permit 13-006, and that doesn't focus so much on the vegetation of the trees, but just painting to match. I don't have the original conditional use permit in front of me, but it may be that it was speaking of the vegetation screening generally and not necessarily as a requirement to have the facility operating. And that's also for practical reasons, right? There's maintenance issues, safety issues with vegetation growing so close to equipment. So there could be certain clearances that apply. Just noting those for the record.
And if
Okay.
I may, Mr. Burns, just add one other point that I don't think is controversial, but just it's there's been some back and forth about SoCal Edison's requirements, the EFR requirements, the city's other health and safety requirements, building code, etc. And I just want to just make the point as a reminder that often these sort of approval procedures are iterative in the sense that the city will have certain requirements. Can you show that the pole owner is approved and all of that? And then there may be through the process, as there was here, some changes to the proposal in order to meet the city's requirements, or in this case, an attempt to meet the eligible facilities request requirements, and that may cause the applicant to have to go back and get further authorization from the pole owner. The city is not taking it upon itself to enforce SoCal Edison's rules. There are generally applicable health and safety codes, General Order 95 issued by the California Public Utilities Commission, things like that. But I don't know that the utilities, I think we have something actually in the standards that applies just generally in the city's requirements, that they do obligate obviously the applicant to comply with the utilities requirements, but they are not the enforcer of the utilities requirements. I just want to be clear about that.
Thank you. Does the appellant have rebuttal?
Yes, please.
And please add 2 minutes onto the appellant's rebuttal.
It's 4 minutes and 26 seconds.
Thank you, I appreciate that. I want to start with something I heard Mr. Akis point out, that this type of issue can be corrected later down the road, meaning if the antenna, if it needs to be, can be pushed out a foot or two. And I think that Mr. Galloway said something similar, that this is an EFR. That is, what we're saying is that you can approve something that is an EFR and get something that's not an EFR. The obligation that the applicant has to demonstrate what they're asking to do is an EFR. And the one reason why that is incredibly significant is that the whole process is entirely different. The discretion the city has, the analysis they can do, meaning they can ask, is this facility going to provide phone service or not? Is it only maybe to deliver broadband to this house? And if that's the case, if it only delivering broadband to houses, for instance, to fixed modems, then there's no federal preemption. The city can say, we don't want these. We don't like these on poles because it allows us to underground them. We don't have conflict with Edison and risk to wildfire safety. You could put this whole area underground with no issues. So I don't think that that is at all a fix that is available to anybody here. The other position that Mr. Galloway presented, which is that basically if an increase in size that would otherwise not be considered to be substantial would be called a defeatment of concealment, then you basically conflate the two and the whole regulatory scheme flies out the window. That was exactly Crown Castle's argument in the Douglas County case. Precisely. They said those two things have to be in separate boxes, and the district court judge said, no, they don't. Sometimes a small change in size, a foot or two or several inches, defeats concealment, and it's within the realm of substantial change or some insubstantial change, but it defeated concealment. And that's also the same thing that League of California's the League of Cities, California Cities also said, in our circuit. So they were less focused on it because it wasn't a factual scenario where the inches counted. But that whole argument has been well dispensed with, at least in 2 cases, and specifically by one judge. I would also do the way that conditions work in approvals do not always match what we would ideally like them to say. There is a requirement that this be the least intrusive means. That was basically what they were requiring, or the most optimal type of concealment. And in order to find that it met that standard, they identified that it was hidden behind trees. They could have made that finding without the tree situation. And hearing, I think that Mr. Akis, I think, pointed out that sometimes trees need to be cut because of safety issues and other types of encroachment. That's definitely true. But here it's the applicant who's asserting in their photo simulation, this is the ideal way to go. They say, look, in parentheses, it is invisible. This is ideal. And then to say later that maybe we should need to be cut, I think that is hard to square in this situation. Mr. McCullough, can you add to that?
I do. And let me start with a couple of things that were stated by the applicant. Ms. Galloway said there's no evidence of abandonment. I think that's incorrect. We addressed this in our case-specific brief, beginning on page 2. It looks like this area burned, and they actually came in for a permit to replace all this equipment. So it may well have been inoperative for quite some time. They never got that permit. Second, even absent abandonment, there's a term issue here. I must take some exception with Mr. Atch's representation. The original permit, the one from 2017, had a 3-year term. We show that in our brief as well, and that term is long expired. So the term is gone. So, you know, this case kind of encapsulates many of the aspects of all of them. This is a situation where, you know, you had residents here who got burned out, and they're rightly concerned about their views, but they're also concerned about whether there's going to be another fire. We have been motivated. Not only, yes, of course, we want to enforce the council's regulations. We want to be consistent with the FCC, but the people here are very concerned about fire. And
I understand. Please conclude. I gave 2 extra minutes.
I will. Thank you. If you take a look at notice of decision, PDF page 28, plans PS 11, there's bushes there again. If you look at our expert RF report, they note that there's some buildings nearby, very close to this structure. And in this case, our experts did take issue with some of the centerline report. And many of the others, they actually validated some of the centerline findings, but said, look, you got an exclusion problem here. That was the main focus of many of the others. Here, they took issue with it. And we briefed that in our case-specific brief. I'll cite that to you. But they observed that they did not do that. So we have bushes in the area. We have structures in the area. It's likely people are going to be there.
Okay.
We got bushes on Busch.
Okay. Applicant.
Yeah.
They
I'd
have
like-
6:10.
Do you need it? Do you need extra time? You have 6 minutes left.
That's fine. 6 minutes is fine. So again, with the Douglas County case, you know, Mr. Strauss wants to stand for the proposition that making it bigger defeats concealment, or at least can defeat concealment. It's very narrow. In the case where you were making it the same width as the utility pole, so that it would be disguised as utility pole, when you make it more than twice as wide and it no longer looks like a utility pole, then it's not a stealth utility pole anymore. It's a stick with a marshmallow on it, and it doesn't, you know, that's defeating concealment. And in that specific fact pattern, I don't disagree. You know, the Crown made that argument, maybe, and it was defeated. But the argument here is simply that just any size change that is not a substantial change under the rules, you can't just say any change makes it more visible. And I think that's ultimately the position that they would say. I would also say that if that were the position where we were trapped between the SEC, the SCE rule and the eligible facilities requirement, like that might actually constitute an effective prohibition under Section 253 and Section 332C of the Act, which is basically the analog of Section 253 for wireless. I don't really think that they're trying to take a position that it's impossible for Crown to have an eligible facilities request here. But regardless, that's not really the right reading of the rule in any case. For you know, towers in the right of way, the rule is the greater of increasing the height by 10%, or separation from the antenna for width, which is really what we're talking about, protrusion. For towers, you know, adding an appurtenance that would protrude from the edge more than 20 feet if it's not in the right of way, or more than the width of the tower, and then involving an appurtenance to the body of the structure would protrude from the edge of the structure by more than 6 feet. So this is a strand-mounted antenna. This is not on the structure. So I would take exception with that and whether that even applies. So I just want to make that note. And then finally, with respect to the RF, again, we've got a professional licensed engineer who has put his license on the line, certifying this is RF compliant, takes account of the structures there. That's the structures are noted. They're all part of the centerline report. You know, I understand that you know, to some extent, their expert may not agree with our expert, but, you know, if we can't trust a professional engineer's report, like the Crown needs to be, any applicant needs to be able to rely on that. Otherwise, the application process just becomes an endless cycle of litigation, and it's going to be a battle of the experts and endless process. And that is definitely not what Section 6409 was envisioning in trying to remove barriers to deployment. It is not what the 2018 wireless removing barriers order was trying to accomplish. And the, you know, again, the 6409 and the implementing rules were upheld in the Montgomery County case in terms of preemption of local and state authority to the extent that they conflict with 6409, and they do tie the hands of the city. So again, I think what that means is some things would need to be, if there were a violation, they need to be dealt with separately outside the process, because that application is still an EFR, it still needs to be approved. Doesn't mean that Southern California Edison can't enforce its rules, doesn't mean the city can't enforce its code. It just means that that doesn't automatically convert it from an EFR to a non-EFR. I think that's all I need to say.
Thank you. Anything further from the city?
No further comments. Good, Gail?
May I say one thing, Your Honor?
I think you've used your time up on this matter.
I have no further comments.
Okay. It is 2:23. And I'm going to go ahead and close this hearing, and we'll go off the record.